For today's coverage, we are discussing a situation in which a woman contracted an STD by having certain intimate affairs in the back of a car. The car was insured by Geico, and recently she was awarded a settlement of $5.2 million. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's coverage, we're talking about getting busy in the backseat and Geico paying for it. This is the case of Mo versus Geico. In this case, Mo decided to have some relationships in a car. Mo got STDs from someone having sex in the car. The car, of course, was insured by Geico, so Geico had to pay out for the injury to the tune of $5.2 million. How'd this come about? Well, that's what we're here to discuss. Let's get started with this. Geico appeals the judgment of the Circuit Court of Jackson County, confirming an arbitrator's award against Geico. After Mo contracted anogenital human papillomavirus, HPV, she submitted a settlement offer to Geico, asserting insured negligently infected her with the disease during encounters in the automobile, and insured's Geico insured automobile provided coverage for injury and loss. Geico denied the coverage and rejected the settlement offer. So yes, she got the HPV, she says, from a tryst in the back of a Geico insured car, and therefore Geico needs to pay for the injury. How exciting. The insured and Mo entered into an agreement pursuant to law and agreed to arbitrate. The arbitrator found the insured negligently infected Mo with HPV and awarded $5.2 million in damages. Thereafter, Mo filed this action with the trial court. Geico moved to intervene and moved to confirm the arbitration. The trial court granted the motions and entered judgment. So therefore, They arbitrated the case, and the arbitrator said, yes, you got the STD from the relationship in the back of the car. The car is insured by Geico. That is a loss that occurred to you in an insured automobile. So Geico has to pay for that loss. How exciting. I didn't know this was an option, but apparently it is. The arbitrator determined that there was prurient activity in the automobile in either November or December of 2017, which occurred in Jackson County, Missouri. The activity in the vehicle directly caused or directly contributed to the Mo being infected with the HPV. Insured knew that he'd been told his throat cancer tumor was diagnosed as HP positive. Okay, so he has throat cancer. That's HPV, okay. Insured should have disclosed the diagnosis to Mo prior to the activity, but did not. Insured was negligent and liable for Mo contracting HPV. The arbitrator found the amount that would fairly and justly compensate Mo for all the injuries is $5.2 million and entered an award of that amount. Wow. As with any court-tried case, we will affirm a trial court's order confirming arbitration unless it is unsupported by substantial evidence, is against the weight of the evidence, or erroneously declares or applies the law. So yes, one of the big things to note here is that this is a result of an arbitration proceeding, not a court proceeding, because, Geico, as part of its policies, pretty much like everyone business ever says, hey, you got to arbitrate these things, rather than bring them in a court of law. Now, that comes with advantages and disadvantages for both parties. But one of the biggest problems, or biggest aspects, I suppose, to arbitration is once the arbitrator rules on something, it's basically borderline impossible to get that to be overturned. Because the Federal Arbitration Act specifically allows for arbitration. So unless you can show some basically erroneous law by the arbitrator, it's basically borderline impossible. So you can't, and the arbitrator gets incredible amounts of discretion, even more so than a district judge, depending on the nature of the arbitration and the rules of the arbiter. So like what evidence comes in and doesn't, and what testimony comes in and doesn't, I mean, the rules of evidence as you know them and love them don't necessarily apply in arbitration. It's a matter of private contract. So the rules are whatever the arbitration association says they are, which is a practical matter, tends to give the arbitrator a lot of ground. Now, typically, the business is like this because arbitrators tend to rule for the repeat customers, like the businesses. But, not so much. And now they're being ruled against and they'd like to appeal. Yeah, not so much. No. Yeah, you're bound by the decision. In case you want to know what an arbitrator looks like, think Judge Judy. Judge Judy is an arbitrator. That's what she is. She is not a recognized court of law. She's an arbitrator. She is a private arbitrator, privately resolving disputes between the parties. And they are subject to rules by the arbitration that they agreed on, Judge Judy. So when she makes judgments, she has the force of laws that reflects those individual parties. And so, this is just Judge Judy on steroids. But yeah, that's, although it tends to be a little bit more formalized than Judge Judy, but still the rules are kind of up in the game. Let's read more about this. Contrary to claim, Geico was not entitled to develop facts and arguments before judgment. This is what I'm talking about. Geico's ability to offer things at trial are significantly reduced because it's not a trial, it's an arbitration. So yeah, rather the relevant proceeding in the arbitration agreement simply gives the insurer the right to written notice and an opportunity to intervene and provides no other rights beyond what any other intervener would. It's well established that an intervener must accept the action pending as he finds at the time of invitation. At the time of the intervention, liability and damages have been determined by an arbitrator and confirmed by the court. Geico, therefore, has no right to litigate these issues. So, yeah, Geico was basically squeezed out completely from the arbitration proceeding. It was a proceeding between the person injured and the injuring party. Geico, the insured, was basically completely excluded, totally. And so, yeah, that sucks, but that's the nature of the agreement you wanted. Geico argues the intervention under the relevant rule provides substantive rights to interveners, including the right to raise legitimate defenses and assert their rights against claims alleged in the suit. We do not deny that an intervener, whether intervention is permitted under the relevant rules, enjoys the same right as any other party in a lawsuit. However, we return to the maxim that an intervener must accept the action pending as he finds it at the time of intervention. So Geico didn't have the right to intervene until the judgment had already occurred, by which point it's kind of too late. But that's what you wanted because that's the nature of the arbitration agreement you asked for, so yeah. As described above, when Geico intervened, liability and damages had already been determined. The rule does not bestow Geico the right to relitigate those issues. Yep. Not so much. Try better next time with your, you wanted it this way, incidentally, because normally you are the one in arbitration and you don't want the other party relitigating the issues at the district court, right? You don't want the other party has a right to intervene, but you don't want them being able to offer issues. So you wrote this thing because normally you have the right to participate and you don't want the other guy intervening. Well, now it's being used against you. So that's just too bad. Geico also asserts the trial court erred by confirming the arbitration award because the state and federal constitution provide a party with the right to define its interests, and Geico was denied the right to litigate its interests before judgment was entered against its insured. Too bad, so sad. Specifically, Geico asserts that confirming the application violated Geico's due process rights under the Constitution, and the trial court judgment violated their constitutional rights of access to the courts. Geico's claim of constitutional deprivations presumes Geico was denied the opportunity to defend its interests relating to MO's claims against the insured, including the ability to challenge liability and damages. But Geico did have the ability to participate and defend those interests, including the ability to challenge liability and damages by entering a defense of insured. Geico did not take advantage of this opportunity and instead denied coverage and refused to defend insured. So one of the things that happened here is that Geico wasn't allowed to the party because initially it denied coverage. So it said, oh, we're not involved in this, right? We're not involved in this thing. So we're denying coverage, so we're not involved. If they had offered a defense instead, right, if they said, okay, we're involved in this, but, we're not going to cover it because of reasons under the contract, that would have been different. But basically, Geico screwed this up because it waived its own rights, is basically the long and short of it. The court is saying, hey, Geico, you had the opportunity to be a party here. You could have insured them, Or you could have said, okay, we are taking on this and we want to fight it in that way as a party. But they said, nope, 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 not us. We're not involved at all. Not us. Don't look to us. We're not going to insure this, right? So they're out. So now the one party has to sue the other party in arbitration. And they said, oh, wait a second. No, they are insured. Oh, wait. No, because now, see, the trial court found the relevant facts. And that now triggers your policy. But you didn't want to participate. So see, this is where Geico screwed up. And now they're trying to come in on the back end. Funny joke. Trying to come in on the back end and trying to say, oh, we want to try it now that we weren't participating in the first place. Yeah, no, you can't really do that. That doesn't really work at all, no. Accordingly, we find the timing of the trial court's judgment confirming the arbitration award did not violate Geico's constitutional rights to due process or access to the courts. Thus, the judgment is affirmed. So that brings us to the end of this case from the Minnesota Court of Appeals dealing with Geico. Geico has to pay $5.2 million in damages because of a whole bunch of confluence of factors. First of all, they wanted their contracts to be arbitrated, and then they didn't want to play in the arbitration because they didn't think they were responsible. So they let the parties fend themselves. And the court said, well, the arbitrator, more to the point, said, yeah, no, the one guy harmed you. But also that, yeah, you're insured. Wait, that's not fair. Sorry. So now you have to indemnify him because it's part of your contract. Wait, no, we shouldn't have to do that. Well, you should have participated. We have the right to participate now. No, you really don't. So yeah, Geico has to pay $5.2 million for a little backseat roll in the hay. At least from the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.